Across America, BP supports more than 275,000 jobs to keep energy flowing. Jobs like updating turbines at one of our Indiana wind farms and producing more oil and gas with fewer operational emissions in the Gulf of Mexico. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
The stress and crowds of holiday shopping can put a damper on your holiday spirit, and you don't always find all the perfect gifts you're looking for. The Virginia Lottery's games make easy and tremendously fun gifts for all the adults in your life, even you. Celebrate the season of gifting with Virginia Lottery Scratchers and online instant games. For more info, visit valottery.com/holiday.
Hey, it's Ryan Holiday, host of the Daily Stoic podcast. When I bought my first house in 2013, part of the way I paid for it was we would rent it out on Airbnb in Austin when there was South by Southwest or F1 or ACL. And then later, when that tiny little house became my office, I would work there. I'd do my writing during the week. Then on the weekends, we'd rent it out to people who were coming in from out of town on Airbnb. And you may be sitting on an Airbnb and not even know it. You've probably had the same experience. You stayed in an Airbnb and thought, this is doable. Maybe I could rent my place on Airbnb. And it's really that simple. You can start with a spare room or you can rent your whole place. Maybe you're traveling to see friends and family for the holidays. While you're away, your home could be an Airbnb. Your home might be worth more than you think. Find out at airbnb.com/host.
Content warning, this episode contains discussion of the murder of 2 girls as well as suicide.
This morning, in a not entirely unexpected move, attorneys Brad Rozzi and Andrew Baldwin essentially filed a motion with the Supreme Court of Indiana. In this motion, they asked for 3 things. They asked to be reinstated as the defense attorneys for Richard Allen in the Delphi murders case. They asked for Judge Fran Gull to be removed from the case. And they asked for a speedy trial, meaning that if they get their wishes, after they are reinstated, they want the trial to happen within 70 days. So not only was that stuff filed, but there was some background stuff filed, some supporting documents, and some of those supporting documents give interesting behind-the-scenes glimpses into some of the early events surrounding this whole affair. And we're going to discuss it all with you all today.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders. Richard Allen goes to the Indiana Supreme Court. Andrew Baldwin and Bradley Rozzi seek to overthrow Judge Francis Gull.
Before we get too much into this, I think to avoid some confusion, I think it's important to emphasize right at the outset that there's basically 2 separate tracks here. There is the track where the question is, was it appropriate for Rozzi and Baldwin to be removed from the case under any circumstances? Did what happened rise to the level where they should be removed? That's track 1. Track 2 is, leaving aside whether or not they should have been removed from this case, was it handled correctly procedurally? In other words, did Judge Gull go by the book and follow whatever the appropriate procedure is or should be before removing them? So that's a separate track. So it's entirely possible for a person to analyze all of this and come to the conclusion, for instance, that yes, they should have been removed, but no, the proper procedure wasn't followed. Or you can come to the conclusion they should have been removed at all. But so those are the issues that we are discussing.
Yeah, it's really important, I think, to take these kind of nuances seriously because this is such a complicated situation. And I think for as emotionally charged as the leak was for everybody, and certainly all the people who care about this case watching from home, I think it's important to look at what's being done in the legal system and is it correct? Is it appropriate? And is it by the book, essentially? So we are looking at this from all those different perspectives. I can say Kevin and I have interviewed and talked to, just off the record, so many different attorneys and people who are experts in this sort of thing. And we've gotten so many different takes. So it's a little bit hard for us to kind of see how all this turns out because it really seems like this is a somewhat unprecedented situation to a certain extent. And so we're watching it unfold in real time and we're trying to kind of give you the best analysis possible. But just keep in mind that there's not really a lot of clear answers here, as there are in other instances where you can look at, oh, okay, here's what they normally do when this happens. We're not getting that clarity at this point. So what exactly is this series of filings here? It sort of outlines, I think, what the old defense, Baldwin and Rozzi, wants to happen. And that is they are reinstated, Judge Gull is removed, and a speedy trial is issued within 70 days.
Yes, it is also important to note, as we always try to note, we're only getting one side of things in these filings. And obviously, when you only get one side, each side is going to be kind of self-serving and try to tilt it towards their side. That's just the way it works. But as you listen to this, keep in mind, we're not getting the prosecution's take on this. We're not getting Judge Gull's take on this. We're just getting the former defense team's take on this. And for instance, that means we have things like what happened is described in a way to basically try to minimize it. Again, as we all know, according to what the defense team has admitted themselves, former employee of the legal defense team, the criminal defense team rather, came into the office and took pictures of crime scene photos and then disseminated them. They admit that themselves.
Yes, they're not disputing that. That's pretty much accepted by all parties that Mitch Westerman, a former colleague and friend of Andrew Baldwin, came into the Franklin office of the criminal defense team, took photos of discovery material that he found on a table in a conference room, left, disseminated those to a man that we designate as R, and that started the leak.
So they acknowledge that, but in these filings, it's described as Westerman took pictures of a few pieces of discovery. So it's not telling you what those discovery items were. They were graphic crime scene photos. And so that feels like it's an attempt to minimize it.
Also, they're not mentioning the fact that
yes.
R was and we have screenshots of all this. So R was communicating with Mark, the man who gave us the photos and gave us the information and then instructed us to go to the police with all of this. And so he's describing all of this information on strategy, defense strategy, who they're going to accuse of being an Odinist next.
So again,
where Andrew Baldwin is traveling to on a specific day.
So again, this so-called leak, it's not just a few discovery items. It's not just a few graphic crime scene photos. It's defense strategy.
Westerman was obviously in communication with the very least someone on the defense team who was giving him play-by-plays. And that was coming out over the course of days, if not weeks, into, dating back to September. So the defense team, the old defense team, pinpoints the moment the leak happened as sometime in August when Westerman took the photos. But this was an ongoing event.
And they also are taking seemingly the position that the leak is just the photos, which they call discovery items. And it's more than that. So I feel at some point they will likely need to grapple with the full extent of the leak.
Yes, because it's the minimization is not what is supported by the evidence, frankly. And it's concerning to see that because we've reviewed things like Richard Allen's letter from prison saying he wants to keep the attorneys on, but he's only reflecting upon the leak of photos and images.
As far as we know.
Well, in that letter, that's all he's reflecting on. There's no indication that he's been told otherwise. And so that concerns me personally, because he should be given the full extent of what happened.
In these filings, they do repeatedly note that Rich Allen never complained about his attorneys, never said he wanted new attorneys. But as Anya pointed out, we don't know what Richard Allen has been told about the nature of this leak. And that raises another issue, which is if there had been a hearing, if there had been a public hearing where Richard Allen is present and all of the allegations against his defense team are aired out and they have a chance to respond, then we would know what Richard Allen knows and we would know whether or not he's okay with them continuing based on what he knows.
He would be making an informed choice, and that would be very clear to the public. And then we could also have the defense being able to say, hey, here's why we don't think we should be kicked off over this. And as Kevin said, it's really not there's the two tracks. Is it even okay to ever throw defense attorneys off a case? What are the ramifications? What are the basically check boxes that need to be ticked off in order to make that happen, if it's even appropriate? And then there's, okay, if that is something that can happen, were all those parameters followed in this situation? And so that's, I think, what is being argued over in this space and with the Supreme Court.
Yes.
The Indiana Supreme Court, just to be clear.
Yeah, you need to make that part clear.
Need to make that part clear. And one other thing that was interesting, we've been kind of looking through right now the verified petition for writ, in which the defense lays out, or the old defense lays out what it wants. And also, they note at one point that Rick's trial strategy is in peril as long as this goes on, as long as this case drags on. And I was wondering what your thoughts were on that, Kevin.
Well, they specify things, for instance, in this context, they are talking about part of his trial strategy was they wanted a speedy trial. And if Rozzi and Baldwin are removed from the case, as they have been, the new attorneys need about a year minimum to prepare for a new trial. So that part of the strategy is gone. And then I believe they're also referring to things like they filed a memorandum for a Franks hearing. They filed requests to have certain pieces of evidence suppressed. And it has not been stated by the attorneys Librato and Scremin if they intend to adopt and use those motions or make those arguments in court. So if Baldwin and Rozzi believe this Franks hearing is absolutely crucial to Allen's defense, if they believe the suppression hearing is absolutely crucial to Allen's defense, and we're prepared to go forth and argue them. If they believe that, and then these other attorneys who are now on the case disagree, and they either don't make those arguments, or they make an argument for a suppression hearing using different arguments, or what have you, this could mean that the original trial strategy prepared by Baldwin and Rozzi would be in jeopardy.
Okay.
From their point of view. Does that make sense?
It does make sense. So they're saying we think this is the best way forward for him, and that would be imperiled by this whole situation. So I can understand that. Should we move on to the next document?
Sure.
Yeah, this was a kind of a series of different filings by these appellate attorneys who are representing.
So we've been talking about some of the items that were in the verified petition for a writ of mandamus.
Yes. And now the relator's brief in support of a petition for writ of mandamus?
So basically, the writ of mandamus they want is we've said a couple of times now, put Baldwin and Rozzi back on, get rid of Gull, let's have a trial in 70 days. And so in the first thing was the petition for that to happen. And then now we're going to look very briefly at the brief in support of that, which is basically where they make their arguments for this is really why we think you should do this.
Yes. They talk a lot about Sixth Amendment issues as far as this case goes, and that this has been a violation of Allen's Sixth Amendment rights. Yeah,
Sixth Amendment, of course, is right to counsel, and they speak about how important it is that a person does have an attorney in a certain proceeding. You do have that right. Did Judge Gull violate that right by taking Richard Allen's chosen attorneys away from him?
In what these appellate attorneys describe as an extrajudicial move. So she's not removing them during a public hearing where Richard Allen is present. This is happening. Essentially what they're saying is behind closed doors in chambers.
And they say certainly there are reasons why you might want to remove an attorney sometime, like for conflict of interest. If it turned out that the defense attorneys had just taken a large payment from the prosecutor's office or something like that.
Right.
That's an obvious conflict of interest. But they're saying nothing like that happened here. There wasn't a sufficient reason. And even if there was a sufficient reason, this was done improperly.
At the Murder Sheet, we spend so much time digging into crime stories that sometimes it's difficult to find the time to plan out and cook elaborate, nutritious meals. That's why we are so excited about our sponsor, Factor, America's #1 ready-to-eat meal delivery service. Our sponsors make this podcast possible. So if you go to factormeals.com/msheet and use our special code MSheet, you're not just getting half off this high-quality meal plan. You're supporting us too.
So I'm obsessed with Factor. I had their creamed corn chicken and their tomato basil chicken risotto recently. Both were delicious. That risotto in particular was amazing. Plus, the whole process was a breeze. All I had to do was pop the meal into the microwave. The food was tasty and flavorful, which is no surprise given that each recipe is specifically crafted by chefs and approved by dietitians.
Having Factor during the hectic holiday season has been a boon, especially with us pumping out so many episodes. Head to factormeals.com/msheet and use code MSheet to get 50% off. That's code MSheet at factormeals.com/msheet to get 50% off.
Have you heard? You can listen to your gripping investigations ad-free. Good news. With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app or visit amazon.com/truecrime ad-free. That's amazon.com/truecrime ad-free. And catch up on the latest episodes without the ads.
Imagine all your audio entertainment available in just one place. That's what the Audible app is all about. With Audible, you can always find the best of what you love or discover something new. Audible has an incredible selection of mystery and thriller titles and originals, like Something Ain't Right by Roger Stringer and Zachary Stringer, The Space Within by Greg O'Connor and Josh Fagan, and the Audible original Moriarty. Membership includes access to Audible originals, podcasts, and tons of audiobooks that you can download or stream as much as you want. And as an Audible member, you can choose one title per month from an ever-growing catalog of titles to keep. The Audible app makes it easy to listen anytime, anywhere. Whether you're traveling, working out, doing chores, wherever your day takes you. New members can try Audible now free for 30 days. Visit audible.com/thrill or text thrill to 500-500. That's audible.com/thrill or text thrill to 500-500 to try Audible free for 30 days.
One really telling sentence in this brief for me is here. On October 9th, 2023, Westerman told attorney Baldwin about his inappropriate, if not criminal, conduct in secretly photographing the discovery items. Rick's counsel informed the state and the court the following day. So, okay, well, we'll unpack some of this, but interesting. I felt in some of the initial filings done by David Hennessy, the attorney who was, of course, representing Baldwin previously in this matter, they didn't really go as hard against Westerman. They didn't go that hard. But here we're actually hearing, okay, there may have been criminal conduct going on here.
They're saying Westerman was a criminal, basically.
Well, I mean, they're saying if not criminal. They're kind of walking up to that line. I don't think they're exactly saying that, but they're saying, that's in the realm of possibility here, folks. And that's, to me, interesting because it's throwing him under the bus a little bit more so than we've seen from at least Baldwin's side of things. And of course, Baldwin and Rozzi are all over this whole matter, even though they're not the attorneys filing it. This whole thing is asking for them both to be reinstated.
Yes, and that's an interesting question. Will a further investigation show that what Westerman did was a criminal offense? There's certainly a very strong possibility that prosecutors will come to that conclusion, and I would not be surprised if Westerman and anyone else who was involved with this, I would not be surprised if they face criminal charges in a court of law.
And the other element of this that I thought was a little bit interesting is that on the 9th, Baldwin hears from Westerman directly, admitting to what Westerman did. And we will get to this later and dwell on it, but I just want to mark it for everyone who is sort of picking up on this. The following day, the state and presumably, and the court hear from the defense team.
Right.
I'm very interested in the time between the defense team knowing and bringing that to the court's attention.
So you're saying you're interested in the delay between the defense attorneys learning who is responsible for the leak and when they choose to share that information with Judge Gull.
I'm perceiving it as a delay, but that doesn't necessarily mean that anything untoward is happening.
Right.
But it's interesting.
This brief has a list of what attorneys Rozzi and Baldwin say Judge Gull told them that she found grossly negligent in regards to their behavior. And I believe we've gone through this list before in some of our earlier episodes.
It bears to restate this and just give everyone a refreshed idea of how the defense is characterizing what Judge Gull's issue with them was. These purported acts of gross negligence included the following: issuing a press release before entry of the gag order, filing motions to protect Rick's health and safety, which the court believed lacked evidentiary support, unintentionally emailing a discovery log to a third party, unspecified improper statements made in the motion to suppress, filing a tort claim notice to preserve Rick's right to seek redress for the conditions of his ongoing confinement, Attorney Baldwin's hiring a lawyer to appear on his behalf on the issue of sanctions or disqualification, and a third party impermissibly photographing discovery without the knowledge or consent of either lawyer.
So according to Rozzi and Baldwin, this is what Judge Gull said her problems with them were. And we hadn't really seen this tort notice that was referenced there. That does pop up in some of the filings here. And basically what that was Rozzi filed something indicating that Richard Allen might sue people affiliated with the Department of Corrections, the Attorney General, perhaps Prosecutor McClelland,
Carroll County Sheriff's Office,
if any harm came to him as a result of his confinement.
Right. So that tort is within, that filing is within this. I believe it's Exhibit H.
I believe there was something else you indicated you wanted to highlight about this particular document.
Well, I was just surprised by this element of it. On page 10, you have, from the old defense team's perspective, you have their breakdown of what exactly happened on October 19th in chambers after Judge Gull has read out all of these things that she thought of as, she characterized as gross negligence. You have the following. The court then informed Rick's attorneys that they had two options. One, voluntarily withdraw their appearances, or two, be disqualified as counsel after the court read its prepared statement in open court. Attorneys Baldwin and Rozzi met with Rick to discuss the matter. Rick disagreed that his trial counsel had engaged in any negligence, and he reaffirmed his desire for them to remain as his counsel. Rick's attorneys informed the court that they believed the court had engaged in an unconstitutional ambush of Rick and his counsel without due process. Counsel also informed the court that they believed their withdrawal was involuntary and done under duress, since their refusal to withdraw would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, and cast Rick, his attorneys, and the merits of a defense in a negative light. Such a public statement risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating an actual conflict for their continued representation. Faced with this dilemma, Attorney Baldwin orally moved to withdraw his appearance, and Attorney Rozzi informed the trial he would file a formal motion to withdraw his appearance at a later date. Attorney Rozzi did not withdraw. It's just interesting to me that they're admitting that they did withdraw and just indicating that they didn't really mean it.
Yeah, they're acknowledging that they withdrew, but they're acknowledging that they said they would withdraw, but they didn't mean it. So that's interesting.
Is that a problem for them? Because I guess my understanding was you're not supposed to lie to a judge under any circumstances as an attorney.
It's not a good look.
Because you can't do the thing where you're crossing your fingers behind your back. Now, I understand what they're saying. I'm very much reading this and seeing, okay, they're saying that if they went out there and faced the music, then that would disparage the public against their client. So they had a duty to not do that. So for people who are saying, well, they were just trying not to be embarrassed, well, they're saying that there was a legal reason for that too. But again, it's just shocking that they're admitting that they weren't being honest.
It's confusing to me if their position is that airing out publicly these allegations against us would harm Richard Allen, then why are they now airing out all those allegations now?
Okay, good point.
It feels like they had an opportunity to air out those allegations then. And as we will discuss in a bit, it feels like there's an argument to be made that they knew what was going to happen at the hearing.
Oh, they definitely. I mean, they're basically admitting as such in many of these documents, and the fact that their client was writing the judge asking them not to be removed indicates that their claims of an ambush are overstated at best.
Right.
But the problem for me with this thing is, were they just trying to slip out the back door so that a record would not be created and they would have an opening to come back? Because I almost wonder if this was a strategic move. Was it a smart one? Because they're essentially saying, we'll withdraw. Like we don't want any of this on the record, so that they could complain about it later.
Excellent question. Because
that's sort of what it looks like to me. And that's a smart strategy because, that's, you can kind of sneak out and sneak back in, I guess. But, I don't, also begs the question of why on earth did the judge, if she wanted them removed, allow that to happen? Why not just have a public hearing? Unless there was an attempt to help them save face.
And in fairness, it's not really the role of a judge to help anybody save face in a situation like that.
No.
If someone's accused of a crime, the judge says, well, let's just have you save face and we'll just forget about the trial business.
Yeah, we don't want to embarrass you for this murder trial. It really just, it raises a lot of questions and why things played out this way.
And to be clear, we don't know if the reason why Judge Gull didn't insist on a public hearing was because she wanted to help them save face.
We don't know, yeah.
That's a speculation we've heard out there a lot. We don't know really anything about the judge's decision-making on any element around this because she's kept it all very, very private.
I think one of the best points made by Hennessy at the Halloween hearing when he went and spoke on behalf of Baldwin was that Richard Allen and the public don't have any sense of what happened behind closed doors in chambers. And so it's hard for anyone to evaluate what her reasoning is for throwing them off. And when something is as serious as removing attorneys from a case, you would hope that things would be playing out in public. So that sort of speaks to a central problem with this whole situation, is that so much of it is closed off. And we have filed for a Freedom of Information Act request around that audio of the October 19th meeting between defense, prosecution, and the judge in chambers. I doubt we'll get it because the attorneys in this case have not gotten it. So I'm guessing that FOIA is DOA, but it's worth noting. A lot of other media outlets have also filed for it, is our understanding.
So another one of the documents included with this filing is a letter written by attorney Brad Rozzi to Judge Gull on October 12th, 2023. There's a few things in this letter that we think really cry out for a comment. So we're going to read a few excerpts from it and discuss. Andy has offices in 3 separate locations, but primarily works out of his Franklin office. In the far back of his office building, Andy has a personal office which sits next to his conference room. Throughout this case, we, the defense, utilize the conference room as our home base in terms of storing diagrams, photographs, and other exhibits that are involved in this case. We have also used the conference room for our defense team meetings and to generally review discovery. This includes searching through the 20 or more hard drives that we have been provided by the state, various thumb drives, and other discovery documentation. I would estimate that 90% of the discovery and related materials in this case are generally located in Andy's office. Andy has a friend by the name of Mitch Westerman. Mitch has a law degree from Valparaiso and at one point in the past worked as an employee at Andy's firm. Mitch is also Andy's personal friend. It is my understanding that Mitch had a girlfriend in the Franklin area and therefore would routinely stop by the office when he visited his girlfriend. So it's interesting for one thing. I just want to highlight this peculiar fact. It's interesting that in this letter to the judge, which Rozzi presumably is now okay with being made public, he is saying that Mitch Westerman was visiting a girlfriend in Franklin. And I say that because Mitch Westerman is a married man.
Yeah, this letter from Rozzi is definitely a lot more pointed than I think the earlier things from Hennessy, vis-a-vis Baldwin. But of course, Westerman is not his personal friend. It's Andy's personal friend. So yeah, that struck me as him throwing someone under the bus there, because there's not really a reason to say he's out visiting a girlfriend as a married man. You could just say he was visiting someone or a friend or just he was in town.
Yeah, so that seemed interesting. And does it also bring the girlfriend into the mix in some way? I don't know. It's an odd choice.
Yeah, I don't know if it brings the girlfriend in if she's just unconnected to the legal world and is just a random person, civilian who is, hopefully not involved in this.
But if she does prove to be connected to the legal world and part
God.
of this community, that would be something I imagine we'll end up talking about at some point. But let's get back to the letter. Andy communicated to me that Mitch was a fairly skilled strategist and that he would sometimes communicate ideas and circumstances with Mitch to get his feedback. Andy reported that he did that on occasion in this case. At no time did Andy ever authorize Mitch to duplicate or take physical possession of any exhibits or documentation in this case. During the week of October 2nd, the defense became aware of a gentleman in Texas who had claimed that crime scene photos had been leaked and that Andy was the party who had leaked the photos. Naturally, this called for some immediate disclosure. Andy and I discussed the matter and believed that it was important to communicate our concerns with the prosecutor in court. This disclosure was accomplished through the emails he received from us last week. On Monday, October 9th, 2023, Mitch Westerman showed up at Andy's office and asked for a few minutes of Andy's time. Andy reports that during the conversation, Mitch acknowledged that he had made a mistake, and in fact took it upon himself to access Andy's conference room and photograph some exhibits that he discovered laying on the table. We believe this occurred back in August when we were preparing for the first round of depositions. In fact, Nick later confirmed that they, the prosecution, believes that the docs possessed by Westerman are the same or similar to the exhibits that were offered up by us during deposition. Westerman then reported to Andy that he shared these images with his military friend, who is not associated with the defense in any manner. This man then apparently distributed them to a man in Texas. The man in Texas is the same individual that was accusing Andy of intentionally leaking these documents. Mitch Westerman then apologized to Andy for what he had done and indicated that he would do whatever was necessary to make things right, including talking to the police. This conversation between Andy and Mitch Westerman occurred around 4 p.m. on Monday, October 9th. At 4:48 p.m., Andy shared with me what had occurred at his office in Franklin via email. I did not see the email until the morning of October 10th as I attended a school board meeting on Monday afternoon at 5 p.m. and thereafter spent some time with my kids. The next morning, Tuesday, October 10th, while at work, I discovered the email. I then immediately communicated with Andy. We agreed that we needed to disclose these facts to Nick immediately, which we did. This occurred by way of a phone call with Nick just minutes before we spoke with you yesterday afternoon.
Subtle results, still you, but with fewer lines. Botox Cosmetic, out of botulinum toxin A, is a prescription medicine used to temporarily make moderate to severe frown lines, crow's feet, and forehead lines look better in adults.
Effects of Botox Cosmetic may spread hours to weeks after injection, causing serious symptoms. Alert your doctor right away as difficulty swallowing, speaking, breathing, eye problems, or muscle weakness may be a sign of a life-threatening condition. Patients with these conditions before injection are at highest risk. Don't receive Botox Cosmetic if you have a skin infection. Side effects may include allergic reactions, injection site pain, headache, eyebrow and eyelid drooping, and eyelid swelling. Allergic reactions can include rash, welts, asthma symptoms, and dizziness. Tell your doctor about medical history, muscle or nerve conditions including ALS or Lou Gehrig's disease, myasthenia gravis, or Lambert-Eaton syndrome and medications, including botulinum toxins, as these may increase the risk of serious side effects. For full safety information, visit BotoxCosmetic.com or call 877-351-0300.
See for yourself at BotoxCosmetic.com.
A couple of things there. First of all, there is certainly an acknowledgement there. They're admitting that Baldwin was sharing strategy-type information with Mitch, and that they're not saying that Baldwin was tricked into that. They're acknowledging that Baldwin chose to share this confidential information with Mitch.
Because he felt that Westerman was a good strategist.
Yes. So that's one thing.
That's surprising.
That jumps out at me there. The other thing that really, really jumps out at me there and leaves me confused and full of questions is we can all agree that this leak was a huge deal. It was tremendously important. It may have been important enough that it got Baldwin and Rozzi removed from the case. Andy Baldwin learns about who is responsible for this leak. He learns that it is a former member of his team, someone he trusted, that he basically bears moral responsibility for this. He learns this at 4:48 p.m. He sends an email to Rozzi. And then that's it.
Yeah.
Why doesn't he? This is so important. Isn't it worth a phone call to Rozzi?
Multiple phone calls.
Isn't it perhaps worth a call to the judge that night? He then just waits for Rozzi to read the email the next day.
That's shocking to me. I don't really feel like that makes a lot of sense. Rozzi, when he gets it, seemingly acts with all swiftness. And once he gets it, seemingly starts running with it, contacts McClelland, contacts Gull, conference call. But I'm baffled by that, to be honest. It's
Baldwin
shocking.
gets this information from Westerman around 4 p.m., sends the email 4:48, and then just goes
dark. Radio silence. I really feel that if we were in a professional situation where I'd received news that something I had done was going to possibly, get us in a lot of trouble, or at the very least cause a huge headache.
Especially if it was something that concerned a matter you'd already been talking about with your superiors.
Right. I would certainly be in touch with you immediately. And if you were not picking up because you were doing something, I would be leaving messages indicating that you need to call me back right away. That's a call, not an email.
Yes.
It's several calls, I think. Several calls and several urgent voicemails. That's shocking to me. I don't know what to make of that. I don't even really want to speculate about it too much because I just don't understand it.
I don't understand it either. I'm flabbergasted.
Again, we're seeing a tonal difference. Rozzi's going harder about Westerman. Rozzi's giving more information about... This is the really only acknowledgement in anything that the defense has filed, indicating that Baldwin was giving Westerman strategic information about what they were going to do for Richard Allen, which, as we've mentioned, damages Richard Allen's defense, because if it's out there on YouTube, then it's not necessarily going to be a good surprise for the defense to spring and kind of maximize the benefit of. It's just you're not holding your fire properly, and it I don't know, it's damaging for him. Yeah, this letter is just something else. So one element that Rozzi addresses is what should happen to him and Baldwin over this. Obviously, he's not advocating for them to be taken off the case, but he's giving his own thoughts on this, and I thought this would be interesting to read. Is disqualification appropriate? Our client, Richard Allen, has a Sixth Amendment right to counsel of his choice. If the government moves to disqualify defense counsel, the burden is on the government to show that any infringement on defendant Allen's choice of counsel is justified. At the same time, it has long been recognized that trial courts do have the power to punish misconduct of attorneys and others. The extent that a court would resort to the extreme remedy of disqualifying a lawyer, nearly all of these circumstances involve a lawyer engaging in some conflict of interest. Rules 1.7 through 1.11 generally address conflicts of interest. None of these rules are even applicable in this circumstance. The rules are designed to provide guidance to lawyers and to provide structure for regulating conduct through disciplinary agencies. The mere fact that a rule is a just basis for a lawyer's self-assessment or for sanctioning a lawyer under the administration of a disciplinary authority does not imply that an adversarial party, the prosecutor, has standing to seek enforcement of the rule. Any violations of the rule should be brought to the attention of the disciplinary committee, who would then process the allegations in the normal course of business. Simply put, the rules are not intended to be used as weapons to seek disqualification for tactical or other similar reasons.
So what do you make of that?
Well, a couple of things. He's essentially acknowledging that punishment may be at hand when things are going wrong, but he's also saying that you can't just kick us off because, that would benefit the prosecution. So, I mean, he's making some good points there. The fact that this was written, let's see the date on this document.
I believe October 12th, right?
October 12th.
This is a week before the October 19th hearing where they were ambushed and apparently had no idea they'd be disqualified.
When he's arguing, here's why you shouldn't disqualify us, Judge. So again, I just, there's a history of overstatement here that I don't think benefits them. I think it would be better to just play it closer to the vest rather than stretching so much, because I think it undermines credibility. And I'm not even saying that I think they have some very good points here about should this even have been done in the first place? Yeah. Maybe not. The answer is maybe not. And in that case, there needs to be something happening to rectify that if that's the case.
Yeah, I'm not sure it should have been done. I have grave concerns about how it was done.
I'm in the same boat as you.
David Hennessy, I thought, made an outstanding point where he said at whatever hearing took place where it was decided that these men couldn't represent Richard Allen anymore, Richard Allen should have been present. Richard Allen, if the decision was made in judges' chambers because of pressure or what have you, Richard Allen should have been present there. He should have heard what was being discussed and had all that information.
Yes, I agree. Ultimately, this is about him. It's not about legal egos. It's not about dueling judges and defense teams. It's about Richard Allen and giving him a fair trial. And everything should be in service of that. That being said, the amount of overstatement, to put it mildly, in some of these filings is overstatement when it comes to, what the defense is doing, what the old defense is doing, and then understatement when it comes to things that they're admitting to have done wrong is astounding to me and really does not do much to further their credibility there's been a lot of that. It's like stretching the truth to the point where it snaps. And I don't really see how that benefits putting that in writing in this situation.
Let's get back to this letter. I wanted to jump all the way to point 8. What is the practical circumstances created by this issue? First, the only photograph that appears to have been disseminated amongst the public is that of the F tree. The photograph in and of itself is not overly gruesome. There is no evidence to suggest that the crime scene photographs of the 2 girls have been distributed to the general public. To the extent they are distributed, the information has already been consumed by the public as it was specifically detailed in the defendant's recent Frank's memorandum filed with the court. Moreover, in the natural course of the litigation, there is an expectation that these images will be displayed in the courtroom at a forthcoming suppression hearing and at the trial in this cause. All of these matters are scheduled to occur within the next 3 months. Naturally, the defense's most significant concern is that the victim's family members not be forced to endure the stress and violation of privacy that would come with the widespread dissemination of this information. Unfortunately, the exposure of these images is imminent and part of the unfortunate side of the legal process in cases of this nature. The defense has nothing to gain by deliberately disseminating this information to the public. In fact, the opposite is true. The likelihood of public backlash is significant and serves no legitimate purpose to Mr. Allen's defense. There's a number of things to unpack there. First, taken literally, they're acknowledging there at the end that this leak has the potential to harm Richard Allen because of a backlash. So that's interesting. They also say there's no reason for the defense to want the images to be distributed. I think I've said on the podcast before that in my view, there is nothing in those images that support or debunk any particular theory of the case. With that said, there's certainly many people out there on YouTube who have seen these images and who believe strongly that what they see supports the defense's Odinism claims.
Yeah, I would say YouTube tends to be a more pro-defense space, and I mean like virulently. I mean to the point of being conspiracy theorists. So if YouTubers seeing these pictures makes them think that Richard Allen is innocent, and then they spread that information to their audience, that's helpful to Richard Allen. So there is potentially a way it could be helpful. God knows. Can I just say, God knows this defense team has courted and flirted with and wooed these YouTubers.
Yeah,
even citing one of them in a legal brief.
Yes.
So that's not an accidental byproduct. That loyalty has been a relationship that is cultivated over time.
So if disseminating these images results in YouTubers thinking their client is innocent, that is a benefit to the defense.
Does it matter to the general public, who most of whom have never heard of these YouTubers? No. But the defense has put an outsized importance on these YouTubers, so I think they think it's important.
I felt it was interesting that in this paragraph, Rozzi basically says, oh, these crime scene photos aren't so significant because we've already discussed details of what the crime scene looks like in graphic detail in the Frank's memorandum. That reminds me of the classic joke where a man kills his parents and then asks for mercy from the court because he's an orphan.
Yeah. I mean, yeah.
And then the other thing there is they say it's not a big deal because it's going to be displayed in court shortly. And I think we understand that something being displayed in court is entirely different from it being published on the internet. When something's displayed in court, it's shown to the jurors. It's not picked up by TV cameras. It's shown to the jurors. They don't get to take it home with them. They look at it while they're discussing the case. And then those images, once the court proceedings are over, are not made public. that is very, very different from publishing it on the internet. And the fact that these images have been spread by irresponsible people everywhere means that for the rest of their lives, these family members, Kelsey, Becky, Patty, all of these people are going to have to be worried that every time they turn on their computer, they might get an email from someone with these images. They might go to a web page innocently and see these images. People are like taking these images and drawing pictures based on them and spreading them everywhere. And all of this is very, very different from it being displayed in court.
Yeah, I think it's very, I mean, as far as I remember, I don't think the legal process involves leaking images to adults with poor impulse control and sick imaginations. It's supposed to be contained within the court. This paragraph is minimizing. It's even the just incredibly callous statement of, let's see how Rosie puts it. The photograph in and of itself is not overly gruesome. This is describing an image of a child's blood. I mean, do they care how they're coming across here? It doesn't really feel like it. And then to be like saying, oh, but we're really concerned about the families. I think this could have been written with a little bit more of an ear for this moment and how it would come across to the public, I guess.
And then there's a section in the letter where he talks about former HLN reporter, current Court TV reporter, Barbara McDonald. Yes,
which is interesting because Barbara McDonald's post and sort of report on Court TV in which she put out an image that she said was kind of from sources explaining the splatter of the F tree photo seems to have been in part what motivated aspects of the leak from what we can tell.
Yeah, people were upset. People on the defense side seemed to be frustrated because they felt that whatever Barbara McDonald put out there wasn't entirely accurate. And so they wanted to put out the accurate.
And by them, we're talking about R, who was messaging back and forth with Mark and kind of was saying she's getting this wrong. And so the fact that you have Rosie sort of obsessing over that in this letter is interesting as well. He's essentially saying, oh, she's talking about leaks too, and she got this information. It's not.
So it's interesting because it's like R was very upset about this Barbara McDonald incident. And look, it turns out Rosie was also very upset about it.
Yeah.
That's an interesting, I guess, coincidence. I don't know.
I mean, it was a lot different than what they showed, in fairness, but it's interesting.
It seems that Barbara McDonald, whatever information she got, didn't you say you believe it came from before the gag order?
No, I don't believe that necessarily. I don't know, but I just think it's possible it did.
That it came from before the gag
She
order?
may have gotten this information before the gag order came down, in which case it doesn't, it's kind of just already out there. And I understand.
And also Barbara McDonald wasn't showing pictures of a child's blood.
No, she wasn't. And
Barbara McDonald is a reporter who's been on this case for years. She has great sources. She has a wealth of information available to her. If Barbara McDonald goes on Court TV and reports something today, it does not necessarily mean that she learned it today.
She may have been sitting on it for a long time, for all we know. That being said, I understand what they're saying in a way. They're saying that the other side has had all these years to put out stuff that they wanted. We've basically been gagged. It's not fair. I get that. I understand that, and I sympathize with that to a certain extent. I think that's a fair point. I'm just saying that we don't know when exactly. If Barbara McDonald said on air, well, yesterday my source called me up and said this, then okay, I think they have a point there. But if this is just something she got for years but didn't feel like she was really able to run with it until recently.
I think people were keeping details about the crime scene close to the vest for a number of years. You can argue if that was right or wrong. But if she had information about this tree years ago and was told we need to keep that under wraps.
And she may have said, well, if it ever starts coming out, can I report this? Fine.
Yeah, and it started coming out thanks to the
So it shifted her thinking and therefore shifted what she was doing. Again, we're speculating. We don't know from Barbara McDonald what happened. I'm sure she's not going to go into depth on any of this. I'm just saying Nor should she have to, but I'm just, that would compromise her sources potentially. But I'm just saying that it doesn't really mean that there's an ongoing leak to her at this very moment.
But it is interesting, again, that R the man who disseminated the photos, was very upset about this Barbara McDonald incident. And Rozzi obviously is also very upset about it.
We've mentioned Mitch Westerman a bit. Should we talk about his affidavit quickly?
Do it. Why don't you read it? Why don't you read the whole thing?
I'll read the whole thing. Buckle in, everybody. No, I'm just kidding. It's very short. It's, frankly, strangely short. Affidavit. Comes now Mitchell Westerman being first duly sworn, under oath, and states that the following information is within his personal knowledge and is true to the best of his knowledge. 1. I was in Attorney Baldwin's office building waiting to visit with Andrew. He was in his office either meeting with a client or on a telephone call with the door closed. I went into the conference room to wait. 2. I observed printed copies of photo evidence on the conference room table. I took pictures of a few of them. 3. Andrew Baldwin did not give me permission to take photos of the printed copies. He was not present, and he did not have any knowledge that I took pictures of the evidence photos. 4. I am freely and voluntarily typing and signing this affidavit on my own accord because it is the truth. So sworn to this 18th day of October 2023, Mitchell Westerman.
So yeah, that's a pretty brief affidavit.
That is a very short affidavit. Does not mention what Rozzi copped to, which was that Baldwin was also talking about strategy with him. It only paints a picture of the incident with the images.
Yes.
I would wonder, how did he gain access to the conference room when I'm sure there's a lobby in this office where people could sit down and wait for somebody?
It also doesn't discuss the dissemination of these pictures. He's not admitting that he shared them with anybody.
Yes, if you just read this and you had no idea what was going on, you might think that the leak ended here, that he just had them and didn't share them with anyone, which of course we know not to be true. Why do an affidavit where you're not admitting to everything?
Well, I don't know, but the key thing is that Baldwin wanted support. He wanted it out there in these filings, I would assume, that he did not know about it. And that this wasn't done with his permission. And also, in terms of whether or not they're being ambushed on the 19th, that hearing, it's interesting. They had this affidavit in their pocket on the 18th. So it seems like they were prepared.
Right. I'm just surprised at how short this thing is and how scarce on detail and scarce on what happened afterwards. And it really doesn't tell you anything other than the idea that Baldwin was unaware that this was happening. Of course, now that's the point, because it's going to be supporting, from when it's filed, it's going to be supporting Baldwin's contention that he didn't do anything wrong and he needs to stay on the case. But it's just surprising from a getting down to the truth matter of things. It really doesn't do that.
And then they also have a couple of things filed here where they want court proceedings to stay while this is in process. In other words, they don't want the new defense attorneys to go and be filing and arguing motions while it's possible that these former defense attorneys might come back. There's also some paperwork there detailing the efforts they've made to get a transcript or a recording of the October 19th meeting in Judge Gull's chambers. As we've said, we've tried to get some sort of record of that. I know a lot of other news agencies have tried to get a record of that.
For what it's worth, we haven't even heard back, so I don't even know.
Certainly, I think it's fair to say that not only do Baldwin and Rozzi have a right to a transcript or a recording of that meeting in chambers, I think all of us do, because this is a tremendously important case. And it seems like something really important that would completely alter the future progress of this case happened in chambers that day. And I think we all have a right to know the details.
I concur. Yeah. It's as we've talked about, there's so many tracks here. It's what happened, should it have happened, was it allowed to happen, did it happen in the right way? If it was allowed to happen, what's happening now? In order to understand what's happening now, I think we need to understand what's come before. And a lot of this feels like it should have been taking place out in the sunshine. Hopefully more sunshine will come and illuminate some of what's going on so we can better understand it. And that's talking about both on the judicial side with what's happening with Judge Gull and her decision-making and her record-keeping in this case, but also, frankly, the leak itself, because some of these documents raise more questions about that. Some of them also raise more questions about the concept of gross negligence. And is a judge even allowed to remove attorneys when even if they feel rightfully that gross negligence is happening? What is the definition of gross negligence? How do you arrive at that determination? What should happen in order to get to that determination? Does anything need to happen? Can a judge unilaterally just do something? Or
the relationship between a client and his counsel is very important, and it should not be disrupted without really good cause.
And just in the by the book way that anyone would expect for such an important situation to go down. Just like if you arrest somebody, there needs to be probable cause. There needs to be different things checked off the box to really go forward. And you want to make sure that that's happening at every step of the process of such an important and high profile case. You can't just make things disappear or say, well, no questions allowed here. People are going to have questions. And unfortunately, I think that this whole thing is kind of grinding the case to a halt to a certain extent, this whole dispute between the judge and the former defense. And I think it's not great for Richard Allen. I don't think it's great for the families of the victims or the interests of justice.
I think it gives the justice system in Indiana a black eye.
Oh, yeah.
I feel the whole thing has eroded people's trust and faith.
And understandably so, in my opinion.
So hopefully the Supreme Court will step in and render their opinions relatively quickly so things can get back on track.
Absolutely.
And we will be keeping an eye on it and sharing our thoughts and analysis on it all with you. Thank you so much for listening. Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
1, 2, 3, 4. Those are numbers, but you already knew that. If you want to know what number you're going to pay each month for your car, use Kelly Blue Book My Wallet on Auto Trader. They're really good at numbers. Auto Trader.
Botox Cosmetic, out of botulinum toxin A, FDA approved for over 20 years. So, talk to your specialist to see if Botox Cosmetic is right for you.
For full prescribing information, including boxed warning, visit BotoxCosmetic.com or call 877-351-0300.
Remember to ask for Botox Cosmetic by name. To see for yourself and learn more, visit BotoxCosmetic.com. That's BotoxCosmetic.com.